Hello and welcome to these training slides on the Mental Capacity Act and Deprivation of Liberties Safeguards. This is the first of 3 videos which will cover mental capacity, assessments, best interests, and inherent jurisdiction. In addition to the Human Rights Act, the British Institute for Human Rights stated that human rights are basic freedoms and protections that every person has, simply because they are human. Human rights are about people being treated with dignity, respect, and fairness, having a say over their lives and participating in decisions that are made about their care, support, and treatment. On this slide, there is a list of human rights that can be interfered with by the very act of care provision. The Mental Capacity Act, or MCA, introduced the Deprivation of Liberties Safeguards, known as DOLS, as a protection against breaches of the Article 5 rights. That is the right to liberty. It also gave us the Court of Protection, which safeguards other human rights, particularly Article 8 rights, which cover the right to private and family life. The Mental Capacity Act was amended to bring deprivation of liberties safeguards into law. This was to prevent breaches of the Article 5 human rights, the right to liberty and security. There was a gap in the law where people who lacked capacity were being detained without recourse to legally challenge that detention. This was known as the Bournewood Gap. This was what DOLS was brought in to solve. So if a person lacks capacity and is placed in a care home or hospital subject to 24-hour continuous supervision and control, not free to leave and the arrangements are responsibility of the state, then a DOLS application needs to be made to ensure those restrictions are in the person's best interest. That is to protect the Article 5 human rights. The very fact of placing someone in a care home or hospital interferes with their family life, as can carers supporting someone in their own home, especially if the person lacks capacity. You cannot use deprivation of liberty safeguards to address Article 8 issues. That is, the right to family life. Any Article 8 issue needs to go to the Court of Protection. For example, this could be restricting somebody's contact with family members, perhaps if there are safeguarding concerns. Anything that interferes with someone's private and family life needs to go to court. Where there is any concern such as numerous unwise decisions, a mental capacity assessment must be undertaken. Repeated unwise decisions may suggest an issue with the person's executive functioning. It is important to assume capacity unless there is a concern that this may not be the case. Then a mental capacity assessment must be undertaken. You must define what the choices are and provide all the relevant information to the person in relation to the choice to support them to make their own decision. This meets all practicable steps if someone makes repeated unwise decisions that places them at risk. But a word of caution: people with executive functioning issues may present very well in interview, so evidence from a range of sources should be used to formulate your decision. The mental capacity assessment is time and decision specific. Can someone make the decision at the time it needs to be made? Some people with executive functioning impairments can say all the right things, but not put them into practice at the material time. That's the end of the first part of this video series on mental capacity. You can now move on to part 2. Thanks for watching.